Welcome to Video 5 on the Mine Health and Safety Act, focusing on legal liability. Section 65 outlines when the Chief Inspector must or may instruct an inspector to hold an inquiry. This includes incidents resulting in death, injury, or serious illness, or suspected contraventions of the Act. An inquiry may also be called for if there is a health and safety concern or if requested by certain stakeholders. The Chief Inspector of Mines also has the discretionary power to direct an inquiry into any accident or occurrence resulting in serious injury or illness, any unsafe practice, or any contravention of the Act. The Chief Inspector is also empowered to conduct an inquiry if requested by a registered trade union, a health and safety representative, or an employee if no representative exists at the mine. The concept of general duty of care is central to occupational safety and health legislation. This relates to broad responsibilities of various persons connected with the work or working environment, including employers, employees, and self-employed persons. The duty of care is legally owed by one person to another. Examples include an employer providing a hazard-free work environment and employees taking reasonable care for their own safety and health, and that of others. Statute law is developed by the government and includes acts and regulations. It is enforceable, and breaches can lead to prosecution. The general duty of care concept originated from common law and has been incorporated into statute law. Common law arises from civil actions when a person seeks justice for being wronged by another party. Common law claims often seek monetary redress and are established through court precedents. Employers have a common law duty to ensure the reasonable safety of all their employees. Strict liability or absolute liability is legal responsibility for damages, even if the person was not at fault or negligent. Vicarious liability refers to liability for the negligent or criminal acts of another person assigned by law, where the principal is responsible for the agent's actions. An example of vicarious liability is an employer being liable for an employee's negligence within the scope of employment. However, a defendant engaging an independent contractor is not usually liable for their acts or omissions, as an independent contractor is not subject to the defendant's control over the work methods. Vicarious liability can be defended by showing, quote, reasonable steps were taken to prevent unfair or bad treatment by workers or agents. These steps are context-dependent but may include policies, training for all staff, and a complaint handling process. Examples of reasonable steps an employer can take include training new staff on appropriate workplace behavior, regular training for supervisors and staff on discrimination law, annual review of workplace policy, and implementing a serious and private complaint process. Indemnities involve one individual taking the obligation to pay for loss or damage incurred by another. The right and duty to indemnify typically arise from a contractual agreement, which protects against liability, loss, or damage. Section 86A on criminal liability states that an employer, manager, agent, or employee commits an offense if they contravene the act, causing death or serious injury. An employer is also equally committing an offense if an employee's act or omission within their scope of authority is an offense, and the employer connived at it or did not take reasonable steps to prevent it. For the purposes of subsection 1, simply issuing instructions to prohibit an act is insufficient proof of taking all reasonable steps. Furthermore, the defense of ignorance or mistake, or the defense that the harm was caused by an individual acting within the scope of the employer's employ, may not be admitted. Section 91 of the Act states that any person, including an employer, who fails to comply with any provision of the Act, a regulation, or any instruction, commits an offense and is liable to a fine or imprisonment. An employer is liable to a fine under Section 55B if they contravene or fail to comply with the Act, a regulation, or certain conditions and instructions. This excludes provisions of Chapter 3 or Section 83. An employer is not liable to a fine under Section 55D for failing to comply with a standard in a code of practice if that standard exceeds a compulsory standard in a guideline from the Chief Inspector of Mines, and their conduct meets the compulsory standard. Section 92 addresses penalties. A person convicted of an offense under Section 87 may be sentenced to a fine or imprisonment determined by the court. Offenses under Section 90A or BI may face penalties applicable to similar magistrates' court offenses. Conviction under Section 90C2 may lead to the penalty for perjury. Any other offense without an express penalty may result in a fine or imprisonment not exceeding 6 months. A person convicted of an offense listed in Schedule 8, Table 1, may be sentenced to a fine or imprisonment not exceeding the period in column 2. An owner convicted under Section 86 or 86A may face permit withdrawal, or a fine of 3 million rands, or up to 5 years imprisonment, or both.